Well, we've got some breaking news we're going to get to now. Jack Smith's election interference case against Donald Trump. Well, the judge in D.C., Tanya Chutkan, just unsealed the special counsel's 165-page redacted motion on presidential immunity. Joining us now, MSNBC legal correspondent Lisa Rubin. It is 165 pages. We've had it for all of, I think, 4 minutes. We obviously haven't been able to go through all of it. Still, this was what we thought would be sort of a mini trial. Here is the evidence we have against Donald Trump in regards to what happened in 2020. Is there anything so far that is jumping out to you now that we didn't know about before today?
Well, Katie, one of the things that I would just point out is that we obviously know who the government thinks Donald Trump's most important co-conspirators are. In this indictment, there is a description of 6 co-conspirators, the majority of whom have been definitively identified before. That having been said, one of the things that pops out to me immediately is how many people here are identified just by P numbers, meaning they're not people alleged to be co-conspirators, but they are people who are alleged witnesses or participants in the event. And there are so many of them that even on page 13, which is as far as I've gotten, there's a reference to P76, meaning there are at least 76 people listed in this description, this detailed recitation of the facts that the government wants Judge Chutkan to see relevant to her immunity determinations that we know are involved here. And many of these people are people who came from the campaign world. That's the other thing that jumps out to me immediately, is just the identification of so many people from the former president's campaign who were involved in what the government is now describing as purely private activity designed to ensure that he remained in office. That matters because for purposes of fulfilling the Supreme Court's mandate in terms of immunity, anybody who worked for the campaign alone and never was a member of executive branch staff, those contacts between them are, according to the government, fair game and should be fair game according to the Supreme Court as well, which recognized there is a realm of private conduct that could be within chargeable conduct for the former president.
I would like our team to go through and find out if there are any references to Vice President Mike Pence in here, because that is one of the big arguments. They believe that some of the actions that Donald Trump took with Vice President Pence are still admissible, even though the Supreme Court said that they would largely be covered, I'm paraphrasing here, largely be covered by presidential immunity because of the relationship between the president and the vice president. I know Jack Smith wanted to argue that there are exceptions there, and that they have proof that would be that would overtake the Supreme Court's threshold for making that immune. The interesting thing is this whole argument is based on private versus public conduct, and when you're looking at just the beginning of this filing, I'll read you just the first part of it. The defendant asserts that he is immune from prosecution for his criminal scheme to overturn the 2020 presidential election because he claims it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. Working with a team of private co-conspirators, you just mentioned that, Lisa, the defendant acted as a candidate when he pursued multiple criminal means to disrupt through fraud and deceit the government function by which votes are collected and counted, a function in which the defendant, as president, had no official role. So when you have J.D. Vance out last night saying, no, this was just free speech and, this I'm focused on the future, this is what the Democrats and a lot of other Republicans are still arguing, which is that Donald Trump had no role in this election.
Correct.
He got the results just like everybody else did. Yes, he can file lawsuits because he doesn't trust the results in X, Y, or Z county. But once those multiple lawsuits are filed and then dismissed, that's it. But he keeps going on, still claims the election was stolen to this day, and finds it to be such a necessity to believe this lie that J.D. Vance, his vice president, has to keep telling that lie on the campaign stage, even though he said privately he knows Donald Trump lost.
Yes, and I want to go back to something that you just asked me, which is about the role of former Vice President Pence here. There are definitely recitations about conversations between former Vice President Pence and former President Trump. And that's because the government's contention is it depends on how Pence and Trump were interacting with each other. If Pence were behaving, for example, as a core advisor to former President Trump, that's conduct that the Supreme Court would consider immune from prosecution. But if they are having conversations about their status as candidates, or even conversations in which Pence is really acting as the president of the Senate, which is not an executive branch role, and Trump is acting as a candidate, those are fair game. And so you see, for example, starting on pages 12 and 13, bulleted list of conversations between the two of them, starting on November 4th, in which Trump presumably asked or allegedly asked Pence to study up claims of voter fraud in states that they had won together to determine whether they could bring legal challenges, and ending with conversations on December 21st in a private lunch where Pence encouraged Trump, according to the government, again, not to look at the election as a loss, just an intermission. And then there was a private discussion in the Oval Office in which Trump allegedly asked Pence, what do you think we should do? Pence said, after we have exhausted every legal process in the courts in Congress, if we still came up short, you should take a bow. And so
also, okay, go finish that thought.
I was just going to say, I expect that as these pages continue, that's only page 13 of the brief, that you will see much more detail from the government. And I just want to remind you and our viewers that when the government asked for permission to file this brief in the first place, and they estimated that it would be about 180 pages long, they told Judge Chutkan that they thought roughly half of that would be devoted to a detailed factual proffer. So we're talking about roughly 75 to 80 pages, because the last 30, as I understand it, are basically consumed by detailed footnotes, and we can already see some of them here. Yeah. But roughly 75 to 80 pages of this factual proffer, and I'm only on page 13, as you noted.
So I've just done a Pence search on my phone throughout the document, and he's on 44 of the pages so far. And what I find interesting is that they're going through minute by minute the events of that day, and they're talking about what Donald Trump was doing, what Donald Trump was tweeting at the time, but they're also going through media coverage and showing what reporters were doing and who reporters interviewed and what those people were saying. On page 80, for instance, they're talking about Fox News's coverage of the Capitol. About 2:20, video of the crowds on the Capitol lawn and the West Terrace were shown alongside a chyron stating certification vote paused as protests erupt on Capitol Hill. At 2:21, an on-the-street reporter interviewed an individual marching from the Ellipse to the Capitol who claimed to have come to Washington because President Trump, this is a quote, because President Trump told us we had something big to look forward to, and I believed that Vice President Pence was going to certify the electoral votes and or not certify them. But I guess that's just changed, correct? And it's a very big disappointment. I think there's several 100,000 people here who are very disappointed, but I still believe President Trump has something else left. So you get a number of those interviews where people are mentioning Pence. You also get the hang Mike Pence chants that were heard on the Capitol. And you get Donald Trump's tweet. Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones on which they were asked to previously certify. USA demands the truth. When they are trying to overcome that threshold, how do they do that? How does this information help them say that what he was doing with Vice President Pence was not a part of his official acts?
Well, I think part of it is to show that, for example, the tweets, right? I want to bring you back to the Supreme Court's ruling for a second, because they say that the president has broad authority to communicate with the American public as the president. But there may be instances where, for example, using his tweets, he really is functioning as a candidate and not as president. They are not backing down from certain of those tweets, as you noted. And one of the reasons that the government is fixated on that is because they want to show not only what Donald Trump knew and what he was ingesting at that time, which may account for the minute-by-minute recitation of what Fox News was airing, but that in his communications, he wasn't doing anything official. Again, we're talking about January 6th, a date on which the current president of the United States has absolutely no official role when it comes to election administration.
I want you to go to page 89, Lisa, if you can, because this is where they get into the defendant's interactions with Pence. They argue the only conduct alleged in the original original indictment that the Supreme Court held was official and subject to at least a rebuttal presumption of immunity was the defendant's attempts to lie to and pressure Vice President Pence to misuse his role as president of the Senate at the congressional certification. The Supreme Court stated that whenever the president and vice president discuss their official responsibilities, they engage in official acts, and further explained that because Pence's role at the certification was a constitutional and statutory duty of the vice president, the defendant was at least presumptively immune from prosecution for such conduct. Accordingly, unlike all of the other threshold determinations that the court will have to make about whether the defendant's conduct alleged in the superseding indictment was official, with respect to the defendant's conversations with Pence about Pence's official role in the certification proceeding, the court can skip to the second step, whether the government can rebut the presumption of immunity that the Supreme Court held applies to such conversations, because the executive branch has no role in the certification proceedings, as we've been talking about, and indeed the president was purposely excluded from it by design. Prosecuting the defendant for his corrupt efforts regarding Pence poses no danger to the executive branch's authority or functioning. It's part of the argument they're putting forward.